Hello and welcome back to What Do I Know? This next series of videos I'm going to be doing is going to contain 12 videos. The series of videos is going to be entitled What Do I Know? Why did CEC's investigations into HPC and what happened fail and be declared unlawful, and now have no standing and lie in complete tatters? There are 12 grounds that were found in the judicial assessment for why the investigations that were done were not lawful. I'm going to go on record and say not just myself, but residents and the Hamforth Ratepayers Association Independent Party have asked Cheshire East to address this, and Cheshire East officially have refused. They were even so naive, and I'm going to have to say this, childish enough to say that the findings of the assessment, which are findings, actual findings, were only allegations. No, they're not. These are findings. These are actual findings of fact. So what I'm going to do now is I'm going to read out what the 12 grounds were, and what I'm going to note in there is under those grounds how many counts were under those grounds. And what's going to happen is each ground is going to get its own separate video. So once I've quickly read through these grounds, I'm then going to do ground 1. So here goes. This report explored and analysed what were at the time allegations for assessment made in relation to the investigations carried out regarding Hamforth Parish Council and the events that befell it between June 2020 and May of 2021. As I say, the assessment took these grounds as allegations, but has now confirmed them as findings of fact, actual fact, and that are backed up with a lot of evidence. So, ground 1 was failure to notify a subject matter that they were under investigation. That's a breach of Article 8 Human Rights Act 1998. This kind of breach was found on 2 counts. 2. Failure to serve complaints against an individual and then adjudicate them, thus preventing a fair hearing. Breach Article 6 Human Rights Act 1998. 2 counts. Ground 3. Failure to provide correct and proper investigation documents for mandatory agreement by all parties. 3 counts. 4. Failure to notify parties of the disallowing of evidence, thus preventing a fair hearing. Breach Article 6 Human Rights Act 1998. 3 counts. 5. Narrowing of the investigation against individuals without any reasoning. Breach Article 6 Human Rights Act 1998. 3 counts. Ground 6. Deliberately failing to maintain the confidentiality of said investigation. 4 counts. Ground 7. Allowing a discriminatory, predetermined and biased approach to the investigation, thus prejudicing certain parties. Breach Article 6 Human Rights Act 1998. 3 counts. 8. Appointing an inexperienced and unqualified person to carry out the investigations. 1 count. 9. Using a photograph of an individual seen in a personal and private background, thus occasioning discrimination against that person. Direct discrimination under the Equality Act of 2010. 1 count. Ground 10. Use of evidence acquired illegally. Breach of the rules of evidence. 5 counts. Round 11. Use of evidence barred due to prior illegal usage. Breach of the rules of evidence. 1 count. On the final ground, ground 12. allowing the publication of investigatory reports with allegations not supported by any evidence. And I'm going to finish here by saying they did find defamatory statements made against persons in those reports. That's not good. I'm sure you will agree. It finished this first part of the report saying, this report will inextricably show how these 12 allegations were proved findings of actual fact and are now provable occurrences which legally render the investigations redundant and ineffective. The analysis will also show, as you'll find, that those responsible for conducting the investigation to a lawfully acceptable standard fell well short of that level, and that in many cases their actions or inactions not only occasioned but directly led to serious breaches of law. The mishandling of this investigation led to an outcome which was greatly skewed and wholly inaccurate. The skewed outcome led to the vilification of 3 innocent persons, the inordinate stress of which led to the sudden and unexpected deaths of 2 of them and the serious illness suffered by another. This investigation, and this is the clincher before we move into ground 1 full breakdown. This investigation was horribly botched, sinisterly contrived, inadequate, inept, and superficial. It did not in any way, shape or form attempt or even get anywhere near investigating what had gone on, exploring the factors, and exploring all available evidence and all reasonable lines of inquiry. That's pretty damning to start with, and we've not even gone through the grounds. Now, before I do ground 1, this is how this breaks down. It starts with the title of the ground, and then it has the law, and then what we move into then is we have an impact statement. Now, I was allowed to do the impact statement because I was the only survivor of the 3. And as it was held, I was so well versed with the evidence, the facts and everything else that had gone on, that it became my duty, I was given to do this statement. After the victim statement, impact statement, is the conclusion that was reached. And the conclusion will show why the ground is proved and why the investigation failed on that ground. So that said, here is ground 1. Ground 1. Failure to notify a subject matter that they were under investigation. Breach Article 8 Human Rights Act 1998, 2 counts. When undertaking an investigation, it is crucial to adhere to the provisions of the Human Rights Act of 1998. When beginning that investigation, it is paramount that the following procedure is followed without evasion or equivocation. There are 10 steps, and these are that 1. All parties who are subject to investigation are formally notified. 2. Those parties are advised to what extent they will be involved. 3. They will be advised what the scope of the investigation is. 4. They will be advised what the intended or desired outcome or outcomes of the investigation will be or are to be. 5. Who the proposed investigator is, together with a right to object as such. 6. What evidence the subject can hand over to the investigator for consideration and analysis. 7. The clear allowing of legal representatives to be involved and how they can register their instruction to be so involved. 8. what, if any, allegations are to be faced and by which subject members. 9. All complaint numbers in this case have to be included so that members know what the investigation will be addressing. And 10. Who the instructing party or parties are and why they have opted for an investigation. It's at this point I just want to quickly advise that the idea of having an investigation didn't come from Cheshire East. It actually came from our legal advisors who wrote no less than 11 letters requesting one, but we didn't get the investigation that we'd hoped for at all, hence why we had to take this option. It goes on. The duty to notify persons that they are subject of investigation lies with the party responsible for instigating the investigation. So in this case, it's the Monitoring Officer of Cheshire East. And that would have been Mr. David Brown. In this case, the duty lies squarely on the shoulders of Cheshire East Council's Monitoring Officer and his department. Crucially, all these points have to be addressed at the beginning of the draft and final investigation reports. There will be a further analysis of these requirements under Ground 8. One important thing is when you notify an individual who's going to be subject to investigation, as you'll find under Ground 8, there are a number of exemptions. And what you have to do is you must apply those exemptions and you must document their application in your report, reasoning why they either apply or why they don't apply. And if need be, referring to any evidence which you must exhibit. As you'll find out, that didn't happen. Report goes on. Furthermore, what must be considered and fully documented at this stage of an investigation, and here we are what are known as the exemptions from notification. These exemptions allow for the waiving of the right of notification and therefore the disqualification of the operation of Article 8 Human Rights Act 1998. There are 4 exemptions. These exemptions include 1. A notice need not be given if a subject to the investigation has waived the requirement to give notice. In other words, I don't need notice. I don't need notice, you're not giving me one. 2. The power is exercised by an officer of a domestic enforcer. It could be the police, Border Force, HMRC, anybody with those kind of powers, or the investigation founder who reasonably suspects a breach of the enforcer's legislation. So if there's been a serious breach of law by someone and you put them on notice, could be a risk that they're going to diddle away with evidence and you're not going to be able to have an effective investigation. 3. The officer or investigation founder reasonably considers that to give notice would defeat the purposes of the investigation. In other words, you're gonna put them on notice, they're under investigation, and if you don't want them to know because you feel that they could abscond, they could hide evidence, destroy evidence, alter evidence, or nobble witnesses, tamper with witnesses, hinder witnesses, try to frighten witnesses, anything like that, exemption. Don't give them notice. And finally, number 4, it is not reasonably practicable in all the circumstances to give notice, in particular because the officer or investigation founder reasonably suspects that there is an imminent risk to public health or safety. Well, shock horror, that is an exemption. If you think by putting somebody under investigation, and I know this is extreme, you think they're going to go out and they're going to start harming people or put people at risk, or there's going to be a safety issue one way or another, don't give them notice. Catch them by surprise. These exemptions are commonly used and should be noted at the beginning of the report to relay their applicability or non-applicability. Look into the reports published into HPC. These, concerningly, were missing and absent. Inquiry showed that there was no reasonable explanation for why these exemptions and their consideration should have been missing. There was no evidence seen which demonstrates whether or not these exemptions were so applied or discounted as inapplicable, as should have happened. It is certainly clear that none of these exemptions would have applied to the late Councillor Tolver, the late Councillor Burkle, or even former Councillor Brewerton. It goes on. The only form of notification that is held on record was one dated the 30th of September 2020, and it was a letter received by the late Councillor Tolver, BT, on the 1st of October 2020. This was received by email. Both former Councillor Brewerton, AB, and the late Councillor Burkle, BB, were shown this by BT. AB immediately stated that he had suspicions over this letter, as there were glaring defects in it, which include, inter alia, 1. There was only one standards complaint number. There should have been 3, as there were 3 in existence against BT at the time this was received. 2. The letter was unsigned, which, for the noted author, was not commonplace. It was either electronically signed or physically signed, and it wasn't. 3. It did not contain any of the information noted in points 1 to 10 above. Remember those points? It was totally defective. It is noted here that AB did make contact with the supposed author, who asked to remain anonymous. AB was clearly told and shown that the author knew nothing of this letter, certainly wouldn't have sent it in the defective state it was in, and would have signed it either with their own physical signature or their digital signature. Therefore, BT was never fully notified of his full position. Of importance, the notification letter must also contain the identity of the investigator which the party responsible for setting up the investigation wishes to appoint. So in this case, that would have been Mr. Mark Robinson of Bevan, Britain. And it would have given everybody to do a little bit of research into him to see whether or not he is the correct person for the job, and to actually say whether or not they agree to his appointment. It is critical to note that the appointment must be agreed by all subjects to the investigation. It is vital to note that the rule of majority applies here. That is to say, that if all 7 parties to the investigation, right, there were 7, remember, and 1 or 2 disapprove of the appointment, they've actually made a typo there. They should actually say, it is vital to note that the rule of minority applies, not majority. There's a typo there. That is to say that if the 7 parties to the investigation, we have 7 parties to the investigation, and 1 or 2 disapprove or object to the appointment, then the rule of minority applies, and the intended investigator cannot be appointed. An alternative must be found and agreed upon. That is the law and procedure. Now we have the impact statement. It's entitled Who's Affected, and the first party is who. There were 3 persons affected by this failure, and they were 1, the late Councillor Tolver, former Councillor Brewerton, and the late Councillor Burkle. There was no evidence to suggest on inquiry, and our inquiry was reasonable in depth, that nobody else was affected. It does appear that the other 4, that being Clark and Councillors Sampson, Moore and Smith, were fully aware that this investigation was to be taking place. Whether they had full documents or not has never been made clear. Right, how were we affected? This is the impact statement. BT was affected as he believed he was the only one of the 3 of us under investigation, and that it was only in relation to 1 investigation or 1 standards complaint. This transpired to not be the case, and as a result of failing to notify him of 3 other investigations, his Article 8 Human Rights Act 1998 right to privacy, right to respect and right to family life was materially breached. There has been no clear application of the exemptions noted above in relation to BT. BT was just suddenly approached without notification and was afforded none of the rights that he should otherwise have been able to enjoy. BB was simply not notified. He received nothing, and he too believed that he was outside the scope of the investigation, that it was thought that only BT was the subject of. He materially prepared himself to be called as a witness. He had no way of knowing nor believing that he was the subject of the said investigation. An email sent to him by Mr. Robinson, which shouldn't have been done because it was known that myself, Brian and Barry actually had a retainer with a solicitor, so it should have gone straight to that solicitor, and Jeshries knew who that solicitor was and should have passed that information on to Mr. Robinson, and Mr. Robinson should have taken steps to check to see what the situation was. As I say, the email sent to him by Mr. Robinson was the first he knew he was under investigation. This cannot be done by the investigator. It must come from the party responsible for the origination of the investigation. In this case, it is the CEC Monitoring Officer's Department and from the Monitoring Officer himself. This did not happen, and therefore BB's Article 8 Human Rights Act 1998 right to privacy, right to respect and right to family life was materially breached. There has been no clear application of the exemptions noted above in relation to BB. Like BT, BB was suddenly approached without notification and was afforded none of the rights that he should otherwise have been able to enjoy. As for myself, my situation is identical to that of BB. I received nothing, and I too believed that I was outside the scope of the investigation, and that it was thought that only BT was the subject of it. I materially prepared myself to be called as a witness. I had no way of knowing nor believing that I was the subject of the said investigation. An email sent to me by Mr. Robinson in January 2021 was the first I knew that I was under investigation. There's a footnote to this. The footnote is quite simple. It states, Mr. Robinson's original email had gone to my HPC account, which the clerk to HPC, Ashley Konsky-Dawson, had advised me was closed and no longer operable at the beginning of January 2020. I advised CEC of this at that time. I now believe that the clerk lied to me in this respect, and that there may have been sabotage or ignorance of my notifying CEC of such a situation. That is still being investigated, but we are getting a lot of intransigence from Cheshire East on that issue. Hopefully that will now stop. Go back to the report. Again, this cannot be done by the investigator. It must come from the party responsible for the origination of the investigation. In this case, it was the CEC Monitoring Officer Department and from the Monitoring Officer himself. This did not happen, and therefore my Article 8 Human Rights Act 1998 right to privacy, right to respect and right to family life was materially breached. There has been no clear application of the exemptions noted above in relation to myself. Like BT and BB, I was suddenly approached without notification and was afforded none of the rights that I should otherwise have been able to properly enjoy. The final count, which I note was identified in the assessment, materially affected myself, BT and BB. It occurred in relation to the events of the meetings of 10th of December 2020 and the decision to include this in the investigation. Again, we all should have been notified, and we weren't. All we received was a threatening email from Bevan Britton, sent on behalf of the investigator, telling us that we had to attend a 3v1, us being the one, meeting with him and two of his colleagues. Again, this cannot be done. We had to be properly notified, and we were not. This constituted a further material breach of our Article 8 Human Rights Act 1998, right to privacy, right to respect and right to family life and rights. Again, there was no clear application of the exemptions. We were suddenly and quite improperly, incorrectly and unlawfully approached without notification. We were afforded none of the rights we should otherwise have been able to legally and lawfully enjoy. I subsequently refused to attend based upon sound and strong legal advice. This point will form part of the Ground 2 analysis that follows. We'll go into that in more detail in Ground 2. In terms of agreeing the appointment of the intended investigator in this case, I certainly would have opposed this appointment as he was not suitably qualified nor experienced enough to successfully carry out an investigation of this complexity and magnitude. BB made it known to myself and BT that he would not have approved the appointment at all, as he viewed Bevan Britton as being CEC's personal troubleshooters who were not interested in finding the truth. BB held great suspicion that reasonable lines of inquiry and crucial evidence would be ignored, and that there was a possibility, strong one, that the investigation was open to predetermination and bias. It was BB's view that all they were focused on was doing a hatchet job to blame and bury someone. BT intended to object on the same grounds as myself and BB. That's the end of the impact statement. Now we get the concluding comments, showing why this ground was proved. Conclusion. There can only be one conclusion that can be reached on this point, and indeed it was the same reached in the judicial assessment. That conclusion was that there was a complete failure to follow correct procedure, in that no proper or no notifications were sent to BB, BT or AB. There is no evidence, not even in the reports, that remotely suggests that the exemptions have been applied or even considered. If it had been decided that one or more of these exemptions applied, then that notification requirement could have been dispensed with, and a full explanation of such made out in the reports. As such, the reports were silent on this point, which exhibits a failure to comply with Article 8, Human Rights Act 1998 on 2 full occasions and 1 in part. It is in part as a notification, albeit an alarmingly defective one, was sent to BT, but it did not cover all the standards complaints made against him, which it should have done. The party responsible for ensuring that this mandatory requirement is complied with is CEC's monitoring officer, MO, as he was the founder and originator of the said investigation. The fact that the investigator also seemingly failed on this ground falls on the MO's shoulders. On the balance of probabilities, this ground is indisputably proved. The assessment noted that BT's, BB's and AB's declared intentions to object to the appointment of the investigator were not given an opportunity to be aired. Would their investigations have been properly acted upon? This assessment believed that the said objections that would have been raised by BT, AB and BB would not have been properly or fairly acted upon, and that it was highly probable that they would have been ignored, and therefore the essential rule of minority ignored. Now that's the end of ground 1. You can see now how ground 1 has been proved. There is no argument about it. All I'm going to conclude by saying is I hope you've enjoyed this first bit. But a little notice, we have had 1 or 2 very silly comments coming in on videos. We do check these, and it's not just me. There is a group, panel, whatever you want to call us. We do daily check them. And I will say this, if you can't write anything mature, don't write it. Because all that happens is you get deleted. Or if you're really lucky, and I don't think you're going to be that lucky, you might get a reply from one of us telling you what we think, basically. So, if you want to watch them, but if all you're coming on here for is to put stupid comments, do us a favour, you're not winning, you never will win, and this is showing you just how far behind you are and how stupid you are in backing a bunch of losers. So I shall be back with ground 2. Stay tuned.